and welcome to the Law Lab. Here we dissect and unpack everything legal. My name is Risa Iris Ewonia, and today I am going to take you through spousal rights. When we talk of spousal rights, they are the rights that come up in the event of a divorce or when a marriage comes to an end, or in legal terms, when there is a dissolution of the marriage. In Ghana, the issue of the rights of spouses in the event of a divorce is something that has gone through a lot of changes in the legal system of Ghana. In the case of Korte versus Marty, the lady was divorcing her husband, and the topic came up as to how their properties will be shared between the parties. The lady was alleging that even though she did not provide monetary support to her husband during the course of the marriage, she claimed that any property the husband acquired in his name ought to be shared between her and her husband, because she believed that she was also a joint owner of those properties acquired. However, in that case, the court reasoned that in our traditional space, when a man who is married acquires property in the course of his marriage, the property he acquires is his individual property, and there's nothing like a joint property acquired during the marriage, especially when the wife did not provide any monetary support. It was previously held in that case that it is the duty of the wife to maintain the home. There's nothing like a man and his wife acquiring properties together in the course of the marriage when the wife did not provide any monetary support to the husband. So in that case, the court gave the principle of substantial contribution, which states that in the course of a marriage, if a party is alleging that properties acquired during the marriage is a joint property, the party alleging it must prove that they gave substantial financial support to the partner who eventually acquired the property in the course of the marriage. That decision was also reflected in the case of Clark versus Clark, where the court reasoned that indeed the wife must substantially contribute to the acquisition of the property in the marriage. In that case, the wife did not have a job, nor did she have any money, but she was alleging that the property acquired during the course of the marriage was that of her and her husband. But the court stated that no, there is nothing like that, especially when she did not provide any monetary support. Her taking care of the home and the children is the duty that every wife has. So there's nothing like providing support in kind. That was the decision of the court in the case of Clark versus Clark. However, with the passage of the 1992 Constitution, Article 18 stipulates that individuals and persons together can acquire property. Article 22 of the Constitution also states that a spouse shall not be deprived of any reasonable provision out of the marriage, and that any property that is acquired during the marriage should be equally shared between the parties, and that spouses have equal access to properties acquired during the marriage. From what I stated earlier, you'd realize that there's a contradiction between Article 22 and the decisions in Korte and Marty and Clark, because those cases stated that the spouses do not acquire property jointly, especially when the spouse did not provide any substantial financial support. But in Article 22, there's no mention of financial support, and in fact, spouses have equal access to properties jointly acquired. However, there has been a new case which has highlighted the new law on spousal rights, and I'm encouraging all of you to read this case. The case is Arthur and Arthur, and in that case, the court classified how properties acquired during a marriage should be shared. In that case, the court stated that where a joint property is acquired during the course of a marriage, the properties must be shared based on the equitable principle, which is equality is equity. This basically means that where the properties have been acquired and they are joint properties, emphasis on joint properties, the properties must be shared in a manner that will benefit all the parties. So it does not necessarily mean that the properties will be divided 50-50. But if in the case of the couple who are trying to divorce, they realize that, maybe the husband doesn't work and the wife is the one working and she acquired all the properties in her name, the courts are going to look at all the factors that affect their marriage. If they have children, or if in the course of the dissolution of the marriage, the man will not be able to maintain himself in a manner that he was doing previously when the marriage was subsisting, the court will tend to share the property in a manner that will benefit the husband if you are looking at it from the angle of the wife, because there must be equity in the sharing of the properties. However, I made mention earlier that the property must be jointly acquired during the course of the marriage. You may think that any property that is acquired during the course of the marriage will be classified as a joint property, but that is not the case, because in the case of Arthur and Arthur, the court gave circumstances where a person can acquire individual property during the course of his marriage. You must always remember that Article 18 grants every person to acquire property on his own. And even though you are married, you should be able to acquire property on your own. In that case, the court stated that where you have been gifted a property inter vivos, that is, during your lifetime, you have been gifted a property, which could either be from your friend or your family member, that property is your individual property, it's your self-acquired property. That property does not form part of the property that you and your spouse acquired during the course of the marriage. Also, if the property was acquired as a result of succession, which is where your family member died, he disposed of his property to you, that property becomes your own property. It's not a jointly acquired property. So let's say during the course of your marriage, your father died and he devised his house at Domi to you. You should know that when you eventually do get the house, that house does not form part of the jointly acquired property. Also, where before you married your spouse, you took a loan and you used that loan to acquire a property, and the loan was not fully liquidated at the time of the divorce, the property you acquired from that loan will be your individual property. However, if the loan was fully liquidated during the course of the marriage, that property will form part of your jointly acquired property. So these are the instances, as per the case of Arthur and Arthur, where a property acquired during the subsistence of the marriage will form the individual property of the person. However, in the case of Arthur and Arthur, the court also stated that the party alleging that the property acquired is a jointly acquired property must prove it. This is a common principle of law, that where you allege that someone has done something or someone owes you something, you must prove it. So if in the course of the divorce, the wife is alleging that a house that is found at, let's say, Ashiye is a jointly acquired property, she must lead evidence to prove that indeed that property is jointly acquired property, and the property will be shared between the parties in an equitable manner. Another interesting point that has come up in relation to spousal rights that I believe we must talk about is based on prenuptial agreements. What is a prenuptial agreement? A prenuptial agreement is a contract between an intending couple, which is a man and a woman who are intending to marry. And the contract outlines how the assets and debts acquired during the course of the marriage will be dissolved or disposed of in the event of a divorce. So basically, it is a trend today that when a man and his wife are intending to marry, they would like to enter into an agreement where, let's say, they write that if we build 5 houses, the man will take 3 and the wife will take 2. Or if we are owing this sum of money, I will contribute this amount to pay that money and you will contribute this. It has been a debatable matter whether a prenuptial agreement will be recognized under the laws of Ghana. Some people believe that prenuptial agreements should be recognized within the Ghanaian legal space because the parties must have voluntarily agreed to include all those terms and conditions in their contract, and they intend that in the event of a divorce, the assets and debts incurred during the course of the marriage should be shared between the parties in the way they want it to be. However, some also believe that they should not be enforced at all because the court must always have the interest of the children at heart. Sometimes when people enter into these prenuptial agreements, they do not always anticipate the number of children they will have and how they will share the properties to those children, which is reasonable because life is very interesting. You do not always know what is coming at you, so it is understandable. However, it's our opinion that prenuptial agreements can be enforced depending on certain circumstances. If a party who entered into the agreement was not coerced or forced to enter into the prenuptial agreement, they should be enforced. Also, if the terms of the agreement are such that it will not limit child support, or in the legal space we call maintenance of the children and the wife, those agreements are likely to be recognized. And if these agreements do not affect the spousal rights of persons that have been enshrined under Article 22 of our Constitution, they are likely to be enforced. Prenuptial agreements are very tricky, so I recommend that if you intend to enter into such an agreement, you consult the services of a lawyer before you sign them, because the likelihood of such an agreement being thrown out of court or not being enforced is very high. Any of the conditions that I highlighted to you are likely to have those agreements refunded. There has, however, been a statutory intervention in relation to spousal rights in Ghana. Under Section 47 of the Land Act 2020 Act 1036, it states that where a person intends to transfer a jointly acquired property during the course of the marriage, that person must obtain the written consent of his spouse. Previously, what many people used to do was that when they acquire jointly acquired property during the course of the marriage, they tend to sell the property to someone else without the wife even being aware of such a transaction. And it usually comes up when the marriage is about to dissolve or during the divorce proceedings. So the spouse is usually taken off guard or is surprised that such a transaction had taken place. But now, Section 47 of the Land Act states that you need the written consent of your spouse before you dispose of a jointly acquired property. By way of recap, I explained what spousal rights are, and I explained that in Ghana, spousal rights are enshrined in Articles 22 and 18 of the 1992 Constitution of Ghana. And also, I stated that the law in Corte and Marte and Clark, which is based on principle of substantial contribution, has been abandoned. That principle, which stated that a spouse must provide substantial financial support to the other spouse to acquire any property before that spouse can claim that a property acquired is a jointly acquired property, has now been abandoned. In the case of Arthur and Arthur, the court stated that a property acquired during the course of the marriage is presumed to be a jointly acquired property. However, there are certain circumstances in which that property will not be a jointly acquired property, which could be based on either a gift inter vivos, succession, or a loan which has not been fully liquidated during the course of the marriage. I also made mention of prenuptial agreements, and I believe that this session has helped you to understand the rights that spouses have in Ghana. Thank you for joining us on this wonderful session. Please like, comment, and subscribe to our videos. Have a lovely day.